Hello everyone. Welcome to the second lecture in the research component of RWA. In this lecture, we will be talking about statutes and regulations. As mentioned before, if you have any questions or concerns, please do not hesitate to contact me before class. I can be reached via email or you can come see me in person. Before we launch into the branches of government, I want you all to know that it is okay if you don't remember all this. I recognize that some of you are poli-sci majors, and this is all elementary to you. However, not everyone focused on this in undergrad or remembers all of it. So we're going to go through some basics of how the United States government is structured. Please don't hesitate to come see me if you want me to discuss this with you further. No questions dumb and no judgment will be passed, I swear. With that being said, there are three branches of the federal government: the executive, the judicial, and the legislative. In this class, we're going to focus on the legislative and executive branches. Next week, we'll discuss case law in the judicial branch. As we progress through the research component, you'll see that our legal system is so complicated because there are a series of checks and balances throughout. Understanding how these branches work together is key to being able to research effectively and knowing that what you found is the law that actually applies to your situation. The executive branch consists of the president and administrative agencies. The president has the power to veto legislation coming out of Congress. See, there's one of those checks in the system. In addition, the president has the responsibility of enforcing the laws that come out of Congress. He's the final signature of each law, and he takes the job of enforcer. In order to enforce those laws, he tasks a myriad of administrative agencies with the enforcement of those laws. Now, administrative agencies are created by statute. Wait, what? So the agency is created by statute, perhaps another check in the system, but agencies are still considered part of the executive branch because they actually enforce the law. The legislative branch is Congress. We will talk solely about the United States government and not about individual state governments, just to keep things simple. The U.S. Congress is bicameral. That means there are two houses, the Senate and the House of Representatives. There are 535 voting members in total, 435 in the House of Representatives, and 100 senators. Each Congress covers 2 years. Of those 2 years, each year is a session. So we are currently in the 114th Congress, and they are in the second session. In January 2017, the first session of the 115th Congress will begin. Please make sure to keep track of any questions you may have on this. I do plan to discuss it in class because some people just tend to get confused, including myself. So the legislative process. It all starts with an idea for a bill. This could be in response to something or could be a proactive measure. To simplify things, we're going to start this bill in the House. That bill is then sent to a House committee and then sent to the House for approval. The House will then send the approved bill to the Senate, and the Senate will send the bill to a Senate committee, and then, once approved, will send that bill to the whole of the Senate to be approved. Once the Senate approves an identical form of the bill as the House did, the bill will be sent to the President. The President then may sign the bill or veto the bill. If the bill is signed, the bill then becomes a public law and is assigned a PL number. It will then be placed in the statutes at large, and then, eventually, it will appear in the United States Code. This is a very simplistic rendering of this process, and I understand that. So now that we have a basic understanding, let's talk about statutes and statutory law. I think statutes can be frequently overlooked, and they're probably the best source of law. A lot of questions can be answered by checking first to see if a statute exists. U.S. law is dominated by statutory law, but just doesn't seem as glamorous as case law. Maybe it's the lack of a storyline, I'm not quite sure. But statutory law is very important. Again, I'm only going to focus on this process from the federal level to keep things simple. So there's a basic pattern of statutory publication. When a law is initially passed, it is published as a slip law. This is in really limited publication. It's then published again in the statutes at large. These are a historical record of all laws passed. They can also be referred to as session laws. I would make note of this because the terms are used interchangeably. Then the laws are broken down by topic and published in the United States Code. Slip law and session law versions of a statute should be identical. So what if they're not? When would you want to look at session laws? Click on the link in the slide to read the Library of Congress explanation. So each of these phases of statutory law has its own citation format. You may ask why you even need to know this. Like, who cares what the public law number is or the statute at large citation? Well, you care, or at least you will or should care at some point in time. If you do any research in legislative history, it's important to know these citations so that you can locate important information related to the development or evolution of the law. If you're trying to interpret a statute for a client, say you're trying to figure out what the intent of the statute is, knowing the history behind the enactment of the law could be beneficial and could be used to sway a judge. A code is the arrangement of statutes currently in effect by topic. So instead of just having books of statutes as they are enacted, these are divided up by topic to make them easier to navigate. With each update, repealed statutes are pulled or removed and revisions are made. So, why should you know about the statutes at large again? Because if you're looking for a prior version of a statute, the only place you may find it is in the statutes at large. So, if a change is made, the most recent code will only show you what is currently in effect. You'll have to do some digging to find out what the law used to be. Keep in mind, when you look in Westlaw, you're looking at the law as it currently stands. You may need to use other resources like Hein Online or the statutes at large themselves to find the prior version of the law. There are two different types of codes. There are unannotated codes and annotated codes. Unannotated codes are going to be what you find on the free government website. What unannotated means is that it doesn't come with extra research information. That is, it will not refer you to cases or secondary sources that may help you understand things better. An annotated code reproduces the original text of the code, but adds in information like cases and administrative decisions, attorney general opinions, legislative history, and secondary sources. Many consider an annotated code to be the gold standard of legal research. They're truly helpful. Please note, anytime you access a code on Westlaw or Lexis, you are accessing an annotated code. This doesn't discount the value at all. Just know that if you find an error or are concerned about wording, you should check an unannotated official code to verify the language. With a statute in hand, your research process may look a bit different than the process you would use when you know nothing about your topic. Again, these steps should just be used as a guide if you lose your way. I mentioned pocket parts and pamphlets. It's not lost on me that updating with pocket parts and pamphlets may be antiquated and falling by the wayside as electronic sources surpass print resources. But you should still be aware of what these things are, and I'll bring examples to class. You may end up encountering them at some point in your internships, externships, or job. Now we are going to turn our attention to administrative regulations. Administrative regulations come from agencies. There are agencies at both the state and federal levels, and overlap frequently occurs. Agencies are tasked with administering programs, regulating the conduct of individuals and businesses, and ensuring public safety, among other things. So, who are the groups issuing rules and regulations? These are just a few examples. There's the United States Department of Agriculture, there's the Equal Employment Opportunity Commission, there's the United States Environmental Protection Agency, and the Federal Communications Commission. As I mentioned before, agencies receive their authority from Congress. The Administrative Procedure Act divides agency action into two groups, rulemaking and adjudicative. We're going to discuss both of these functions. Rulemaking, quasi-legislative. Agencies serve a quasi-legislative function in that they issue regulations or rules that must be followed by individuals and industry. These are meant to help guide the enforcement of the statutes passed by the legislative branch of the government. These rules are adopted through what is called notice and comment rulemaking. There are books written on this process, so I'll just try to explain it briefly. The agency creates the rules and then must publish them for public comment. The public is given a period of time to comment, and then the agency must consider those comments before issuing the final rule. Sometimes the agency modifies the rule, sometimes they disregard the rule completely, and other times they issue the rules as they were. What I find fascinating about this process, though, is that the public gets an opportunity for their voice to be heard. So how do statutes and regulations function together? Statutes come from the legislative branch. Remember, they're passed by Congress. In the statute, Congress grants the agency authority to enforce the statute and issue regulations to aid that. And if you think about it, this makes sense. Who's in Congress? Politicians. And politicians are more the idea people. They may know that the environment is important, and they may be able to come up with a law to help preserve the environment. But they're not typically scientists or economists or experts in the field. They leave the enforcement to the experts in the agencies. This is an example of an enabling statute. This shows where Congress specifically delegated authority to the United States Department of Agriculture to craft rules and regulations to enforce this specific statute. Sometimes this authority will be clearly indicated. Other times it won't be so obvious. So, where do you go to find these regulations? The Federal Register is a publication of the United States Government Publications Office, or the USGPO. It serves as a type of diary or chronological account of the happenings within federal agencies. The Federal Register serves a few purposes. As a diary, it provides the past and present activities of an agency. It also provides future deadlines for the notice and comment period or when a regulation takes effect. It can also serve as a research tool in that it can provide reasoning behind a final regulation or give insight into why changes to the regulation were made. You can locate the Federal Register online or in print in federal depository libraries. Westlaw and Lexis also provide access. I like to note that important information related to specific agencies can also be located on the agencies.gov website sometimes. Now, think of how difficult it might be to find a regulation if you don't know the exact day the final rule was passed. This is where the Code of Federal Regulations, or the CFR, comes into play. It serves as a topic-organized resource of all agency rules and regulations currently in force. This is similar to the United States Code, except that it contains rules and regulations instead of statutes. And here's a list of where you can find the CFR. This is a PDF or a page from the CFR. The top circle shows you the enabling statute, that is, where the agency was granted the authority to issue the regulation. The bottom circle just cites the act that this is related to. Finally, this blue circle is showing where within the Federal Register this was initially published, just in case you wanted to look. Now, I mentioned earlier that agencies also serve an adjudicative function. For the purposes of this class, it's enough that you know that agencies hear cases, typically specific to individuals. The opinions issued by the administrative law judges, or ALJs, typically have no precedential value, but can be persuasive if you're taking a case before an ALJ. We've now finished our second lecture. If you have any questions or concerns, please don't hesitate to contact me, or you can save them for class. Thank you, and I'll see you on Friday.